Welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This is my weekly series covering what matters most in data privacy, and this week we have two distinct developments to cover. First, the injunction on enforcement of the Texas App Store Accountability Act has been lifted, meaning that app developers must comply with the act right now. And second, California's Privacy Enforcement Agency just published guidance that serves as a useful compliance checklist for any companies doing business there. Let's get into it. You may recall that the Texas App Store Accountability Act was supposed to take effect on January 1st of this year, but a district court injunction kept it on pause while a First Amendment challenge worked its way through the courts. That changed last week. The Fifth Circuit lifted the injunction. The court found that Texas made a strong showing of likely success on the merits, and that means the law is currently operative. The First Amendment challenge isn't over, but for now, app developers need to treat this law as in effect. So what does the Texas law actually require of developers? At its core, it requires developers to build an active system that queries the App Store for each user's age category, and for minor users, their parental consent status. Developers have to notify the App Store before deploying significant changes that might affect minor users so that the App Store can reobtain parental consent, and developers must limit how they use any age information they receive. Essentially, it can only be used to enforce age-related protections within the app, comply with the applicable law, and implement appropriate safety defaults. There are also two prohibitions worth highlighting. First, developers can't invoke their terms of service against a minor user who entered into an agreement without the required parental consent. And second, developers can't knowingly misrepresent an app's age rating. Now, before going further, it's worth pausing on something that's easy to miss. The parental consent framework under these laws is broader than what most people are used to under federal COPPA. COPPA applies to children under age 13. These state App Store laws apply to all minors, meaning anyone under 18. The three age brackets the laws use, under 13, 13 to 15, and 16 to 17, are there to calibrate the level of protection, not to limit who is covered. And that last point is actually where Texas goes further than the other states in this space. Texas uniquely requires developers to affirmatively assign age ratings to every app and every in-app purchase, and to provide those ratings along with the specific content factors that drove them to each app store. Other laws require age ratings in the parental consent disclosure, but only if those ratings already exist. Only Texas requires developers to actually create them. Now, here's the practical significance of the Fifth Circuit's ruling for multi-state compliance planning. Alabama, Utah, and Louisiana all have similar App Store accountability laws taking effect on January 1st, May 5th, and July 1st, 2027, respectively. Aside from the age rating requirement I just discussed, almost everything Texas requires, those three states' laws require too. So building out your Texas compliance program now isn't just a Texas problem, it's laying the foundation for a nationwide age assurance program. So the Fifth Circuit's ruling, for the most part, just accelerated the timeline for work that app developers would have had to do to comply with the other state laws anyway. Once the work for Texas is done, the additional work for Alabama and Utah is relatively contained. There are only a few nuances those states add that Texas doesn't have. And once you've built out your Texas, Alabama, and Utah compliance, you're essentially good to go for Louisiana, which is the least prescriptive of the four. So it won't require much incremental work on top of what you've already done. Now, California's Digital Age Assurances Act, which takes effect January 1st, 2027, is a bit of a different beast. That one requires developers to request an age signal from both app stores and operating systems, and has a structure that doesn't align as closely with other laws. So it requires some different thinking, but it belongs in your age signal planning as well. The practical takeaway here is that if your company develops apps, this is the moment to build a real age signal recognition program. Texas is operative right now. 4 more states arrive within the next 12 months. Let's shift now to California, where the state's Privacy Enforcement Agency, CalPrivacy, just published a list of consumer-facing tips for spotting non-compliant websites. On its face, this is a public education effort tied to the National Internet Safety Month. but read it as a compliance team, and it's actually a pretty direct statement of what CalPrivacy expects consumers to be looking out for, and therefore what companies should absolutely have in place. Here's what their checklist covers. Consumers should be able to opt out of the sale or sharing of their personal information, either through a do not sell or share my personal information link at the bottom of the site, or through a notice banner that lets them turn off tracking technologies like cookies. CalPrivacy is explicit that the opt-out mechanism has to be easy to use and easy to understand. Dark patterns are called out directly. Poorly labeled choices, options that don't work properly, processes that require an unreasonable number of steps, or designs that are intentionally confusing should not be present. And critically, companies must honor opt-out preference signals, in particular the global privacy control. On the privacy policy side, CalPrivacy says consumers should be able to find a policy that explains what rights they have, how to exercise them, whether the company sells or shares their data, how it uses that data, and how to access, correct, or delete personal information. The policy should also include a web form for opting out of sale or sharing, and it should describe how the company processes opt-out preference signals. None of this is new law. These are existing CCPA requirements, but the fact that CalPrivacy is packaging them as a consumer tip sheet is worth noting. It signals that the agency considers these baseline expectations. So this is a good gut check. If any of these elements are missing or hard to find on your site, now's the time to close those gaps. So, two distinct developments this week. On the App Store front, the Texas App Store Accountability Act is now in effect, and a wave of similar laws in Alabama, Utah, and Louisiana is right behind it. App developers who haven't started building age signal recognition infrastructure need to move quickly. This is a multi-state compliance obligation, not a Texas-specific one. And in California, CalPrivacy's consumer guidance is a reminder that the fundamentals of general CCPA compliance still matter. Opt-out mechanisms, no dark patterns, and privacy policies that actually tell people what they need to know. As always, more detail on all of this in our newsletter, A Little Privacy Please. I'm Julie Rubash. Thanks for joining me this week. Until then, go enjoy a little privacy, please.